الحمد لله رب العالمين حمدا يوافي نعمه ويدافع نقمه ويكافئ مزيده. فاللهم أخرجنا من ظلمات الوهم وأكرمنا بنور الفهم وافتح علينا بمعرفة العلم وسهل أخلاقنا بالحلم واجعلنا مما يستمعون القول فيتبعون أحسنه. اللهم اجعل أعمالنا خالصة لوجهك ولا تجعل فيها حظا لغيرك يا مقلب القلوب ثبت قلوبنا على دينك. فاللهم لا تحرمنا خير ما عندك بشر ما عندنا. وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم. الحمد لله رب العالمين. والسلام عليكم ورحمة الله وبركاته. How's everyone? Alhamdulillah Rabbil Alameen. Small advice for any class, but particularly for the morning class. Um, always advise the brothers kindly not to send out invitations during the class. And I specifically mean thereby invitations towards sleep. And the manner in which we send invitations to sleep is by folding our arms in this manner and putting our head or our chin in the chest. When a person does this, this is an invitation to sleep. And sleep is a very, very, very kind recipient, and it will receive your invitation well. And before you know it, you've fallen asleep even without tiredness. Now, so aid yourself in the attending of this class by, inshallah, trying to sit in a manner that would not be too comfortable for you, right? Because one of the afat, one of the dangers of the pursuit of seeking knowledge is laziness, you know. So we have to fight this, and we have to have a little bit of mujahada. We have to undergo a little bit of difficulty. Obviously, we can make compromise here and there, sit on your chair and so forth, but try to attend in such a way that you will be awake, inshallah. So what has passed with us yesterday is that we had discussed, we had 3 muqaddimat, 3 introductions, and a preface, right? Thereafter, we went into the integrals, if you want to, or the arkan, the pillars really of a sale, right? And we sketched out the idea of a sale. What exactly does it mean when we say that a sale is taking place? What is the result of a sale? And as we mentioned in the beginning, what are those things that must exist for us to call that thing a sale? And so we said that the sale, as we'll come to discuss its definition very close to the end of the class, and you'll see why. One of the most obvious outcomes of a sale is the exchange of wealth. In order for this exchange of wealth to take place in a manner that is valid, such that the buyer owns the commodity and the seller owns the price, then there are certain elements that must be part of the sale. If these elements do not exist, then the sale cannot be valid. What are these elements? We mentioned them to be 3. The first is that of the contracting parties. And the contracting parties are 2: the buyer and the seller. Right? Then we spoke about the contracted item. And the contracted item also is 2. And it is that of the commodity and the counter value. And we said that the counter value is that which is used in order to pay, right? Whether that be money or otherwise. And we'll come to, when we get to the contracted item, we'll come to see the benefit of distinguishing between the commodity and the counter value, or what they call the thaman and the muthman, right? The price and the price. Then we had lastly the formula, and this consists of the offer and the acceptance of the offer, right? So today, inshallah, hopefully we'll cover the contracted item, not the contracted item. We're supposed to be the contracting parties. So today, inshallah, we hope to cover the contracting parties. And then in addition to that, we want to cover the contracted item. So those are two discussions. And inshallah, hopefully we can get through it. So let's look at the contracting parties. When we speak of the contracting parties, then we speak of the buyer and the seller. In order for the buyer and the seller to validly take part in a contract wherein they wish to exchange wealth, such that both parties permanently own what the other is handing over, they need to meet certain conditions. If it is that they do not meet these conditions, then they cannot validly form part of the sale. It will be as if they're not there. Right? It will be as if they're not there. And I'll give you some examples of this when we discuss it. So we will mention about maybe two conditions, and then we'll mention another two conditions. Right? So for the contracting parties, the first condition that we stipulate, and we're on page number 21, the first condition that we stipulate is unrestricted contractual capacity. Right? Unrestricted contractual capacity. In Arabic, they call it itlaqut tasarruf. Itlaqut tasarruf. Right? So what is unrestricted contractual capacity? So let us look at these three words. The first word that we have is unrestricted. Right? The second word, and so we know what it means to be restricted. So over here, we're saying that the person must be unrestricted. There must be nothing to restrict them. Right? The second word that we have is contractual, having to do with contracts. And here, the third word we have is capacity, and that is the ability to do something. So when we say unrestricted contractual capacity, we mean that they must have the full ability to enter into contracts, and nothing must prevent them from that. Right? And the things that prevent them from that primarily are regulations of the Sharia. Right? Meaning what? That the Sharia must consider this person to be a valid legal entity to enter into a sale. If the Sharia doesn't consider them to be a valid legal entity, most of the time on account of their mental state, they will not be allowed to administer their wealth. And what we mean thereby is that though they might be able to own something, they cannot engage in the transfer of that ownership. So Malna says, since things are known by their opposites, I say this means that none of the two contracting parties must be prevented from administering their wealth or interdicted. And there are three things that limit one's contractual capacity. Right? There are three things that limits a person's contractual capacity. What do we mean thereby? There are three things which, if they are present in a person, the Sharia will say, even though you have money, we are not going to allow you to administer that wealth. We are not going to allow you to engage in the exchange of that wealth with other people. Right? The first of those is childhood. Is childhood. And when we speak about childhood here, we speak about the fact that the person must be baligh. That they must be baligh. Right? They must reach the age of maturity. If this is not the case, in that the person is a minor, they will not be allowed to administer their wealth. They will not be allowed to administer their wealth. Naam. So, Mana says here, in addition to that, that this does not mean that the minor does not have any contractual capacity at all. Rather, he is permitted to grant permission to enter on behalf of the owner of a house. So, if you have a young person, and they are in their father's house, right? The house belongs to the father, so can they allow somebody else to enter into the home, which is a form of benefit? Are they allowed to do that? Yes, they're allowed to do that. Right? He may also give and accept gifts, as is our tradition during the month of Ramadan, when mothers send their children with gifts to their neighbors, in keeping with the tradition of mutually exchanging gifts for iftar. What's Mala speaking about here? Cookies. Right? So they're saying that the child can go and give cookies. The child can go and give cookies, right? And the Mana also mentions here that the child can accept the gift, right? Can the child accept the gift on his own behalf? No. He can accept the gift with the permission of his parent, right? Uh, so it's handed over to the parent in reality, but the child is just accepting it physically, right? So that is in relation to the minor. So the minor cannot transact, they cannot enter into a sale, right? So this is the view of the Shafi'i school, right? And you will find, I would say, almost no difference amongst the Shafi'i scholars in relation to this. Tayyib, what about we send our children to the shop all the time? Isn't it so? Send the child, go there, buy a bread, buy this, buy that. Sometimes we send the child to school, tuck shop, spend money, these type of things. So over here, if we look outside of the Shafi'i madhab, then we find that even within the Shafi'i madhab, but more so outside of the Shafi'i madhab in terms of official positions, you're going to find that when the scholars look at the minor, then they have two terms. The one term is mumayyiz and the other one is ghair mumayyiz. Right? So, who's the mumayyiz? If you want to translate this word, you might say that the mumayyiz is the minor that has the capacity to distinguish. When they make depth of this term, when they delineate this term further in some of the other books, then they say that الذي يأكل لوحدي ويشرب لوحدي ويستنجي لوحدي. So when they speak about the mumayyiz, who is the minor with discernment? They say that the minor with discernment is that minor that has the capacity to eat on his own, to drink on his own, and to do his own istinja. That's a sabi mumayyiz. That's a sabi mumayyiz. That's a minor that has discernment. Right? And I can tell you, I serve in a primary school. You can find, mashallah, students at 10 years old, they don't know how to do istinja. It's possible. Right? It's possible. Maybe because I didn't teach them. That's besides the point. But you can find a minor that doesn't have discernment. But generally, at this age, the minor will have discernment. So over here, for example, the likes of the Hanafi school will say that they have different views. Of their views is that the minor that has discernment, with the permission of the guardian, will be allowed to transact. Some of them will go on to say that they will be allowed to transact without the permission of the guardian, but the contract will be pending. You understand that? What do we mean thereby? If the child goes to the shop to buy something, right? He may engage in that transaction. So he takes the 10 rands and he buys a packet of Lays, right? That sale will be pending. If he gets home and the parent is fine with that, then that sale will be considered to be valid. If not, the parent will have the right for return. Do you understand that? So that's what we speak about. That's what we speak about discernment, right? So that's one view. Another approach taken in the Hanafi school is that the permission for the minor to transact is in relation to what they call muhaqqarat, is in relation to minor purchases. So when it comes to minor purchases of things that we would generally consider to be trivial and not extremely valuable, then they would allow the discerning minor to administer wealth. As for the case where it's major purchases, for example, are we going to allow the minor to go and buy a house? No. Right? The minor might have inheritance. Are we going to allow the minor to, for example, go and buy a motorbike? Right? Over here, even according to some of the views within the Hanafi school, they're going to say, no. Yarhamukallah. No, we're not going to allow this. We're not going to allow this. Right? So you understand this? This is clear? So that's the first. So he says, beware, O honorable student, of conflating the ability to contract with the ability to own, for they are two completely different matters. The minor thus has the ability to own, but he is prevented from administering his own wealth because his contractual capacity has not yet matured. Right? So sometimes it is that we listen to this and we think, well, does that mean that the minor cannot own at all? Absolutely not. The minor can own. It may very well be that, may Allah preserve the parents that are alive, it may very well be that the parent might have passed away, left some inheritance, Does it now mean that the child doesn't own that inheritance? Absolutely not. They own the inheritance. However, they will be given access to that inheritance and to administer it when they reach the age of maturity. When they reach the age of maturity. And I think that the maslaha, the benefit in that is clear. The benefit in that is clear. طيب. So that's number one. The first thing that will limit a person's contractual capacity will be childhood. The second thing is insanity. The second thing is insanity, right? The sale of a mad person is invalid due to his insanity, which deprives one of contractual capacity. Rather, the contracting party must be sane. The contracting party must be sane, right? So when we speak about insanity here, you get different types of insanity. You get complete insanity. You get like a partial insanity. In all cases of insanity, the sale will not be valid, right? So let's say that the person is, they break out sort of into periods of insanity. In those periods, the transactions will not be valid. In the periods where they experience sanity, that will be valid. You understand that? Then you have something else which they term as mughma alay. And mughma alay is sort of the person is it's kind of like a state of, I wouldn't quite say sleep or slumber, but the mind is clouded, right? The mind is clouded. So in relation to this person, the transactions won't be valid. So it's not an insanity, but it's a clouding of the mind, right? In some other chapters, right, examples of that would be, for example, like fainting. You call that person like mughma alayhi, But it could also be on account of the usage of. Okay, that's a separate case. So another case is that of the person being intoxicated. The person being intoxicated. When it comes to the one who's being intoxicated, we find that there's a bit of nuance in the discussion. In that, one of the views that exist in the Shafi'i school in this regard is that يصح ما عليه ولا يصح ما له. So, whatever transactions are to his detriment in the state of drunkenness that he caused himself will be binding. And whatever transactions deliver benefit to him in the state of drunkenness that he caused himself will be non-binding. Ta'ziran. Right? As this is a ruling that's meant to be like a deterrent. So if you find yourself in a state of voluntary intoxication, then the Sharia is going to say, whatever you sold in that state and you didn't mean to sell, it's binding. Right? If it's to your detriment. If it's to your benefit, it's non-binding. Right? So that's of the discussions over there. Other views will say none of his transactions will be valid, but many of the discussions go around this, in that whenever it's to his detriment, it will fall, and when it's to his benefit, it won't fall. Right? So that's important to know. That's important to know. Right? So what do you say about that guy that goes to Long Street and you buy the pie, then you say, is the pie halal? It's a common example, isn't it so? Does he own the pie? Doesn't he own the pie? Right? So, insanity. Insanity will be the second thing that will limit a person's capacity to administer their wealth. The third thing is prodigality. Prodigality, and the Arabic term for this would be safah, or the person would be safi. And we put over there in the footnote, and we said what? That prodigals are persons with normal mental ability who squander their assets in an irresponsible or reckless way due to some defect in their power of judgment. A more common but less precise term would be a spendthrift. So a spendthrift would be an example of a prodigal, where you have this person, they are an adult, they are sane-minded, they are not intoxicated. However, they don't have complete power of discernment when it comes to measuring the value of things. So they will make like foolish purchases. And a classical example of this would be the spendthrift, right? So he says the sale of the prodigal is invalid due to his incompetency, which deprives one of contractual capacity. Rather, the contracting party must be prudent, right? And over here, when we speak about prudent, we use the word Rashid. If any of you are at Mizan, then you would have read Ibrahimu waladun Rashidun. Right? So what's a Rashid? According to the official view of the Shafi'i school, the Rashid is the person whom they are uh, um, they are upright in their matters of religion, right? And they have discernment in the matters of dunya, of worldly matters. So that means that the person will be considered to be a prodigal if they don't make salah. So according to the classical view of the Shafi'i school, that if the person wasn't constant in their salah, then their transactions will not be valid. Right? But this view is not practicable. So what does he say? The prudent person, according to the Shafi'i school of thought, is one who conducts his religious and material affairs properly. That is, he manages them responsibly. When an individual, we're on page 22, when an individual falls short in any of these two respects, then, according to us, he is not considered to be prudent. As a result, his transactions will not be valid. An individual who reaches the age of puberty but does not establish the prayer, by way of example, will be prevented from transacting because he is not considered to be prudent. Right? This is if we strictly follow the Shafi'i school. As for considering the real dynamic, then we will suffice with a prudent being considered as one who conducts his material affairs properly. What does all of this mean? It means that the classical view would have been this, right? But there are other views within the madhab that have sort of become the salient practice, and that is that the person who has the power of discernment with his worldly things will be considered to be prudent. In that he can measure the value of money and he knows, like, I shouldn't spend 100 rands to buy a toilet paper, for example, a roll of toilet paper. And a person who continues to do that, they don't notice that they're having poor judgment in estimating the value of something. So they just spend. They just spend. So this person would be considered a prodigal, right? So in classical law, there would have been a hakim, right? And a hakim, the ruler, would have placed an interdiction on him. They would have declared him as a prodigal. And with the declaration of the hakim, right, it would cause his sales to be invalid. That is why you get another term. Another term is that of the Safih Muhmal, the neglected prodigal. So the neglected prodigal is the person whom they should have been interdicted, but the ruler didn't interdict them. The hakim or the judge didn't place an interdiction upon them. Right? What's an interdiction? When they tell you you can't spend your own money. Right? So when that is not done, then you will technically be a prodigal, but his sales will be valid. Why? Because the invalidity of his sales is dependent on the pronouncement of the judge. You understand that? Another example of this would be a person who becomes bankrupt. Right? So when his liabilities exceed his assets, right, then he won't be allowed to spend his money anymore. Right? Obviously, in excess of his needs, he will have to cut off all other transactions, and the judge will do this to him such that he can only spend that money on his primary needs, and whatever is beyond that, right, will have to be used to square his debts. Will have to be used to square his debts. Right? Do you understand the matter of prodigality? Fine. So you call this, what's the Arabic term? Safa. Right? Now, so that's the first condition. The first condition is unrestricted contractual capacity. Unrestricted contractual capacity means that the person must be in such a state that the Sharia allows them to spend their money however they want to, in the halal way. There are three things that cause the Sharia to take away this right to spend. The first of them is childhood, the second of them is insanity, and the third of them is prodigality. Right? And we explained what those mean. The second condition that must exist is the absence of coercion without just cause. What do we mean thereby? We simply mean that the person must not be forced to buy something, just as they must not be forced to sell something. And I think that somebody asked a question in relation to this yesterday. Right? So what do we mean that the person mustn't be forced? So over here we will introduce, let's look at this term, the absence of coercion without just cause. So the absence means that it mustn't be there. And coercion means to be forced, meaning that the person mustn't be forced. Like they say, force is a crime, right? Then, without just cause. Without just cause means that if we had to take that clause away, then all types of coercion would have been unjust. But because they said without just cause, that means that there's a type of coercion, there's a type of forcing that the Sharia allows. Right? That the Sharia allows. So let's look at coercion. When we look at the matter of coercion being forced, then we can divide them into three categories. The first of them is unjust coercion. And unjust coercion refers to the threat of life and limb in order to enter into a sale. So you have a person, Ml Muhammad Carr explained yesterday, you have a person, Zaid, okay, let's say you have a person, Mark, right? You have a person, Mark, and he's putting gun to the head of Zaid, right? And he says to Zaid, sell me your iPhone 14. Is the iPhone 14 out? Okay. Sell me your iPhone 14 for 100 rands. Now Zaid is under duress. And he gets the impression that this person is really going to kill them. Right? So over here, Zaid will be forced to sell. He would be foolish to not sell it. Right? But will that sale be valid? No, that sale will not be valid. ماذا يترتب عليه? What is the result of that? The result of that is another mas'ala, another case. And that is the case called al-akhdhu bil-dhafar. What is al-akhdhu bil-dhafar? Al-akhdhu bil-dhafar means, I would call it taking by chance. Meaning, dhafar means when you get something kind of skillfully or through bounty, right? Or like skillfully winning something, right? That is the idea of dhafar. So al-akhdhu bil-dhafar over here means that now Zaid was walking sort of in the wrong community and he got himself into this pickle and somehow he ran into a gangster that didn't want to rob him, just wanted him to sell it for 100 rands. Right? I don't know what Cape Town he is in, but this is the case. Right? Additionally, Zaid knows where the den is. Right? So what can Zaid do? Zaid can go and he can go and fetch his phone and put the 100 rand back. And in that way, the Sharia will say that that is a valid doing of Zaid. This is called al-akhdhu bil-dhafar. Right? To reclaim one's possessions when a person's possession has been usurped. Right? طيب, أما كسر الباب. What if he comes there and the doors are locked? The Sharia is going to say, break the door. The Sharia is going to allow Zaid to break the door. Right? طيب, what about if Zaid is weak and he doesn't have the capacity to break the door himself? Can he hire someone else to break the door? No. He must break the door himself. He must break the door himself. If he wants to break the window, he must break it himself. Right? And then the person will have to take their thing exactly, right? And they will have to replace what is not theirs. They will have to replace what is not theirs. Not the window, the money. So he will have to give the 100 back and take his iPhone back. Right? There's a little bit more detail to this, but now, just to throw a span in the works, there's a contemporary case that comes on account of this. Okay, maybe it's not so wise for me to mention it. So, inshallah, when the class is over, then I'll mention it when it's not on the camera. Right? Um, yes. So that is in relation to coercion. So that is now unjust coercion. When the person's life and limb is threatened in order for them to engage in a contract. Right? And the threat must be imminent. The threat must be imminent. What do we mean thereby? We mean that the person can't say, sell me this thing now, I'll shoot you tomorrow. Right? That's not the imminent threat. Right? Or the person says, sell me this thing now or you're going to see. No, 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 no. Right? That's not the imminent threat. The threat must be imminent in that the person is under current duress, right, in order to engage in that contract. Understand? طيب. Naam. Why? Because the golden rule when exchanging wealth is mutual consent. Is mutual consent. Says Allah subhanahu wa ta'ala, يا أيها الذين آمنوا لا تأكلوا أموالكم بينكم بالباطل إلا أن تكون تجارة عن تراض منكم. Right? وَلَا تَقْتُلُوا أَنفُسَكُمْ. Allah says, O you who believe, devour not your wealth between you through falsehood, but only through trade by your complete mutual consent. Right? So there must be mutual consent in that both parties want to engage in this act. Right? So that's the first type of coercion. The second type of coercion is what we termed over here as, Malana mentions it in the Arabic, he speaks about ikrah khafi. We termed it as subtle coercion. What is subtle coercion? Subtle coercion is where there's no physical threat, right, to the person's life or limb, but there is an internal duress to sell something, or an internal duress to buy something. What do we mean thereby? The person might be constrained in terms of their life circumstances and they feel that I have to go and pawn this thing. So I don't want to sell this, but conditions are such that I'm forced to sell it. Right? So here's an example of coercion. But the coercion doesn't exist outside the person. It exists within the person. Right? So you call this subtle coercion. Right? Another example of this is incessant marketing. Right? When a person gets, subhanAllah, if you don't find this much in the West, but if you go to like Eastern countries, then you find that the guy will sell you something whether you like it or not. Right? You go there to that open market, he'll sell you something you don't need. You'll start at 1,000 rupees and he'll get you to buy it even if you have to buy it for 200 rupees. Isn't it so? Right? He's incessant. You feel that you need to get this person off your back. And the only way you're going to do it is by buying this thing. Right? And sometimes it's by incessant marketing. So these are all forms of duress, of coercion. But it's a subtle coercion in that the coercion is not physical, but rather it exists within oneself. Right? Like you'll say, he's mentaling you. Right? He's mentaling you. It happens. You know, sometimes you get a guy, anyways, it happens like that. Right? So what do we say about the subtle coercion? Where a person is forced to sell something. They don't want to sell it on account of constrained financial circumstances or on account of incessant marketing strategies. We're going to say that ikrah khafi will not prevent the validity of a contract. So though I went to go and pawn the thing, right, sort of against my own will, in as much as my financial state went, still I did it externally via my own volition. On that account, the Sharia is going to deem it valid. Why? Because there's no unjust coercion. There's a subtle coercion. And the subtle coercion does not prevent the invalidity of a sale. Right? So I think that should answer the petrol question. Whoever asked it yesterday, they asked it, you know, I don't really want to pay this price for petrol. Right? Artis. Now. So we mentioned unjust coercion. We mentioned subtle coercion. Now we mention, what's the last one? Just coercion. So just coercion would refer to, let us go back to the case of the prodigal, right? Where one of the conditions of becoming a prodigal is that the person is either spendthrift or now they enter into such debt that they're drowning in it, right? So over here, the person might have so many debts. In order to square that debt, right, the judge might force him to sell some of his property. Might force him to sell some of his property. And by his property, we don't mean his house, right? Because you will find that the Sharia looks with great reverence onto owning a house, right? Because it's the need that never goes away. But rather, certain things that are like in excess of his needs that he can sell, the Sharia will force him to sell it. So this will be in one of two ways. Either the Qadi, the judge, will sell it himself, right? Or the judge will force him to sell it. The judge will force him to sell it. In that, the judge will set up a buyer and will force him to engage in that contract. Over here, you have a case where he's being forced, but it's justly. But it's justly. You understand? Now, so all of these laws can exist. These laws can exist, right? There's no reason why a Muslim should go to a non-Muslim judiciary, right? Do we have all the infrastructure to run our own quasi-judiciaries, which will take a lot of burden off the official courts, right? Which is something that has been looked at in other Western countries, North America, right, as well as the UK. That they have also, we also have our quasi-judiciaries in the sense of the MGC, but they operate in a very limited capacity only, like we said, Muslim personal law, if you want to, personal statutes, right? And we've never really been able to like break out of this into other types of law. But in terms of like arbitration, it's very possible for the Muslim judiciary, the body, to set themselves up as an arbitrator, and then Muslims can go there to solve their cases, and they can have the peace of mind of being able to do it via Islamic law, right? The only problem is that it requires the active buy-in of the Muslims, because whether you like it or not, the ruling will not necessarily be binding where state law is concerned. You understand that? So if one of them don't get their way through arbitration, and then they run to the state court, right? And then that also puts the Muslims in disrepute, because you set up a quasi judiciary, right, to be an arbitrator for your cases, and then you're saying people are running towards the courts that you set yourself up to run parallel with, right? So for these type of legal systems to work, and they can work, they require the complete buy-in of the Muslims, right? And when a ruling is passed on the person, right, then they will have to consider it binding upon themselves, right? So it takes a great buy-in from the Muslims, and unfortunately, a lot of times we don't have so much confidence in Islamic law, which is, it's a matter of faith, but also not for discussion now. Type. So we understand this? So what did we speak about now? We spoke about the second condition, and the second condition spoke about the absence of coercion without just cause. When we spoke about coercion, we said that it means to force. When we spoke about this coercion and forcing, we said that there are three types. The one type is unjust coercion, and we explained that to be imminent threat to the person's person, right, to life or limb. When this takes place, the contract will not be valid, and we also mentioned as an offset for that, the person will get the opportunity to retrieve their wealth, right? And we explained the detail thereof. Thereafter, we said that there's something called subtle coercion. And the subtle coercion is not the threat to life and limb, rather, it is the force that sits on the psyche of the person that causes them to engage in that contract into this. Over there, we're going to say it's valid because there's no physical threat to the person, right? The third is just coercion, and we said that this is when the qadi, the judge, right, will force a person to sell something on one account or another. I only gave one example, but there are other examples of that, right? Now, okay, so Mala mentioned here the musadir, and I explained to him. The musadir is one who sells his property after the buyer was extremely persistent, right? So that's like on account of marketing and so forth. Now, this is still 10 minutes, right? Okay, I'm going to explain the last two. So we're now at page number 23. So these, these conditions are stipulated for both the Muslim and the non-Muslim. Right? So for any two people, according to the Sharia, to exchange wealth between one another, these conditions must be met. Unrestricted contractual capacity, in that the person is not a minor, they're not insane, and they're not a prodigal. Right? The absence of coercion without just cause, right, in that there's no imminent threat to life or limb. This must exist for any two contracting parties, Muslim be them or otherwise. Right? Now, there are two other conditions, but they only apply to certain contracting parties, certain buyers and sellers. And what is this? One of them is on account of a specific condition of the commodity. And the other is on account of a specific quality of the contracting party. So when it comes to a specific condition of the commodity, then we say that when the commodity is the Quran or contains verses of the Quran, and here we speak about the Arabic, the commodity is books of hadith or Islamic sciences, then the contracting party, the buyer must be Muslim. Right? Meaning the Muslim can send a non-Muslim slave, for example, to buy it because it's being purchased for the Muslim. You understand that? So in order for the Quran to be purchased or the books of Torah, of Islamic sciences, the person must be a Muslim. Right? Why? Because khawful ihana. Because of, what do you call that word? Desecration? Is that the word? Because out of fear of desecration. Right? Out of fear of desecration. So over here, Maulana has said that if the reason behind making over to a non-Muslim a copy of the Quran or books of hadith or Islamic sciences is calling them towards Allah, da'wah, then it is permitted. With the condition that one is assured desecration will not take place. Right? So can you make that case, for example, in France? No. Yeah, you can see that if you're going to make over a Quran to a Frenchman in France, most likely is going to desecrate it. So you can see that this rule as whereas in the West we have a more like a cordial sort of relationship with non-Muslims. That's not always the case, right? So where fear of desecration exists, the sale will not be permissible and it will be invalid. Where that doesn't exist and the reason for selling is to call towards Allah subhanahu wa ta'ala and the person doesn't fear that desecration will take place, we'll permit it over there. Right? We'll permit it over there. Right? And here Maulana mentions, in a similar manner, we find, an honorable reader, that at times certain unsought circumstances may occur in the marketplace that demand specific preconditions such as these. For example, our common law here in South Africa stipulates that when the commodity of sale is used second-hand, the buyer must have a receipt, proof of purchase. And with its absence, the sale is not valid. Why is Maulana mentioning this? Maulana is mentioning this because sometimes the sale is not invalid on account of the sale itself, but it's on account of extraneous conditions that exist outside the sale that affect that sale, right? And this is here, for example, like food stewards, selling. So, okay, that's a different thing, like as is, we'll get to that. But over here, selling something second-hand, having a receipt is stipulated on account of an unsought circumstance that beset the marketplace, which is the prevalent sale of stolen goods and the presence of an unofficial black market in which stolen goods are circulated. Right? So over here, it's like Maulana is saying, astahsinuhu. I would consider that condition to be legally binding. Why? Because many a times it is that when a person comes to you with a bargain, especially when they come to you in a certain manner, probably stole it, right? What fell off a truck. So that's one. Two is the specific condition of the contracting party. The specific condition of the contracting party is that when the contracting party is called a harbi, he exists in a state that is at war with the Muslims. Right? Then it will not be permissible to sell him weapons or utilities for war. Right? So that sale will be impermissible and it will be invalid. Why? Because they will use it to fight the Muslim. So, for example, to give you a real case, could you sell a gun to Israeli, mathalan? No. Would it be valid? No. Could Israeli sell a gun to you? Yes. Would it be valid? Yes. Right? Type. So that's another example where when the commodity is weaponry, right, then it is stipulated that the contracting party, right, to whom the weapons are being sold must not be at war with the Muslims or belong to such a state. Right? As for the case where it's a non-Muslim but he belongs to the Muslim state, then you're allowed to sell him weapons. Then you're allowed to sell him weapons and Allah subhanahu wa ta'ala knows best. The next case will take a bit long. And it's going to speak about the case where he mentions here the consideration of yeah, we'll speak about the case of selling grapes to somebody who's going to make wine that's going to come, right? But over here, the next discussion, and perhaps it will be good for us to just foreshadow it, is that it will speak about when the case when the buyer or the seller is inanimate. So you're transacting with a machine. What happens over there? Right? So we'll discuss this tomorrow, and we'll get into the contracted item. In order to foreshadow this, I say that when a person transacts, they can either transact on their own behalf or they can set up a proxy. They can set up a proxy, somebody to transact on their behalf. Right? Whatever is stipulated for the original contracting party is stipulated for the proxy. What do we mean thereby? We mean that if you want somebody to sell something or buy something on your behalf, just as you had to be sane, mature, and prudent, so too does the person selling on your behalf have to be sane, mature, and prudent. So, must the computer be 12 years old or 15 years old before you can buy online? What about the vending machine? Must the vending machine get a wet dream, or must the vending machine be 15 years and older? Right? What of this? What of our online purchases, where we're stipulating for the proxy what we are stipulating for the original contracting party? So we'll come to discuss that tomorrow, insha'Allah ta'ala. And we're going to leave the last 3 minutes for questioning. In summary, what did we discuss today? We discussed the contracting parties. And we said that the contracting parties, in order for them to validly enter into a sale, they must meet certain conditions. The first of those conditions that we mentioned is unrestricted contractual capacity. There must be nothing preventing the person from being able to administer their wealth. The things that prevent the person from administering their wealth is childhood, insanity, and prodigality, and we explained what that means. The second thing is that there must be the absence of coercion without just cause. We spoke about 3 types of coercion. Unjust coercion will cause the sale to be invalid. Subtle coercion will cause the sale to be valid. And just coercion will cause the sale to be valid. Then we said that there are certain conditions that apply to specific contracting parties, either on account of the commodity that is being sold, such as the Quran. The person who's buying it must be Muslim, and we mentioned the exception to that. Additionally, the person to whom weapons is being sold must not be at war with the Muslims or belong to such a state. That's all that we discussed today in 50 minutes. Do we suffice for that? Any questions? Well, afterwards.
What stipulates someone as consent? For example, like the state might put someone, but just when someone has the ability to persuade people, all of these things, they seem as a normal person, but they actually have a psychopath there.
Okay, so when we speak about insanity, what do we mean? We mean that I would say a medical insanity. And a medical insanity is different from a psychological insanity. So psychological insanity, you could term the psychopath as insane, but he would not be clinically insane. You understand that? He would not be clinically insane. So if you can book him in, what's the place? If you can book him in Lentegee, is insane. right? If he's what do you call the word, sadistic, we're not going to count that as insanity. Online question?
So, can you sell other than weapons? Can you sell something that you have?
Yes. And so the question is, can you sell other than weapons to somebody that you're at war with? Yes, you can. Right? Yes, you can. And it's always important to note that permissibility doesn't denote preferability. Just because something is allowed doesn't mean it's wise. Doesn't mean it's wise. Yes.
Islamic products like from here, banking.
Hmm.
So, the person obviously negotiate with the Sharia compliant partner of the bank.
Hmm.
Okay. But then what happens is that before he enters into the contract, the Sharia compliant department must get the approval from the main unit of the bank.
Hmm.
So just so happens, and that creates the doubt is that by mistake the Sharia compliant sends the original contract, or the, let's say the non-Sharia compliant contract. So obviously, evident that they first work out the non-Sharia contract, then move it to the Sharia compliant department, and then send you that report. Or then obviously, compliant. And you as a person still enter into the contract knowing that that's what they actually do. Say a smoke screen. It's like the same thing. Or
You're giving a pronouncement now. Stay with the question. So there's a very long question. We're going to come to this when we speak about riba. When we speak about riba, the question is what? The question is that the brother is saying that what if the Sharia, you have a Sharia compliant branch within the bank, right? Then you find that they send you the wrong contract. And you've now found out, and I'm just narrating what the brother is saying here, you've now found out that they actually use this contract in order to set up the Sharia compliant contract. Maybe they look at the figures and then sort of they look at the price on the user's loan in order to determine the markup on the murabaha product. It's probably what you're speaking about. So what is the case of this? Would it be permissible for you to enter into this? This discussion is going to come. The discussion is going to come. To give you some irahat bal, to set your mind to rest, you should know that the validity of contracts is not on account of the validity of contracts is not on account of the price you pay. Just because the price is exorbitant doesn't mean that the sale is invalid. And just because I used another price to measure what my price should be, and that market price is based on usurious loans, just because I use that as a model to price the thing, doesn't make this contract invalid. Those are two separate issues. The issue of fixing a price and the issue of an underlying contract. What is the essential nature of the underlying contract that governs this financial vehicle? These are two completely separate things. You understand that? So when you have the murabaha model, what they call it, murabaha al-amir bishira, right? When you have this model, then the contract that governs that is going to be different from a user's contract. You understand that? And if the bank stipulates the same fees, it's the bank's prerogative. You understand that? It's the bank's prerogative. So is the bank required, are Muslim institutions required to give you a certain price? No. In fact, when there is inflation and prices become extremely high, even in those cases, according to the Shafi'i school, price fixing from the side of the ruler will be considered to be invalid. The Prophet ﷺ was asked once by the companions that, "O Prophet of Allah, things are becoming expensive. Sa'ir lana. Set the market prices for us." Then the Prophet ﷺ said that Allah sets the price of the market. And this is akin to the idea that Adam Smith mentions in his Wealth of Nations. He speaks about the hidden hand. He speaks about the hidden hand of the economy via which things fluctuate. But the hidden hand is in fact the hand of Allah. You understand that? So what is the point? The point is that we'll come to discuss this matter in great detail, where there's a difference between price fixing and underlying contracts. Right? And when we get to Murabaha, Malna will discuss it in great detail, some contentions that people have, and these, unfortunately, are one of those contentions which Maulana referred to as spurious. Okay, I said it's spurious because I translated the word into English, but Maulana used the original Arabic word. Right? But inshallah, we'll come to appreciate why that is the case. It's a very common question, but inshallah, when we get there, you'll be very happy with the answer. Inshallah. What does invalidity of a transaction all entail? So when we say that the transaction is invalid, we mean that there's no exchange of wealth. Means that the thing that, if I say that I'm selling this book for 100 rands, or I'm selling this, and let's say that this is 100 rands, right? And we exchange it. And on one account to another, this transaction is invalid. It means that you don't actually own that, and I don't actually own this. So that is the main result of invalidity, that the transferal of ownership doesn't take place. Then there could be other peripheral matters that come about on account of that, but essentially they will be on account of the invalidity. They will be on account of the non-transferal of products. For example, you have a miner, right? You have a miner. When a miner sells something, when something is sold to a miner, right? And the guardian doesn't allow it. In fact, according to the Shafi'i school, even if the guardian doesn't allow it, it won't be valid. So when you sell something to a miner, and the guardian comes, and he takes the miner's money back, and the miner broke that thing, the guardian and the miner will not be liable for it. And he will have to give his money back. So why? Because you squandered your wealth by selling it to a miner. You understand that? So there's a case where that is the result of an invalid sale in relation to the miner. In that if you sell something to the miner and the miner happens to make it perish, then it will not be liable. For example, if you tell somebody, if somebody owes you 10,000 rands, right? And they have the 10,000 rands in their hands and they must give it over to you. And you tell them, throw it in the sea. And they throw it in the sea, they will still owe you the 10,000 rands. Right? They liken this case to the case of the miner. Why? Because you should have known better than to squander your wealth like that. You should have known better than to squander your wealth like that. Similarly, the Shafi'i school is going to say, you should have known better than to hand over your wealth to a miner. Right? So that's going to, I hope that answers the question. So that same condition will over here, when it comes to the prodigal, there will be a bit of nuance. But in general, the case of bankruptcy, because of the absence of a hakim, you won't be able to establish the invalidity of the contract. So on account of us not having a working court system, you can't actually find the case of a prodigal with an interdiction. Except in a few cases, but generally it won't be. Right? Now. Okay, so now you're not asking a question of fiqh, you're asking a moral question, right? So we're not here to answer moral questions. No, I'm just joking. The discussion will come when we discuss defects, inshallah. So when we discuss defects, we'll mention that discussion over there, and then we'll answer it in more detail, inshallah. Alaikum salam. Excellent. If the agreement is not documented, so we will discuss that when we come to the formula. But according to the Shafi'i school, it will be mustahab. It will be recommended to document a major purchase, but it won't be wajib. All right. So the statement is enough. Statement is enough.
You're speaking about quite basic sales between parties. But I think common practice. So, for example, if you have a long-term relationship with, say, for example, an investor, and there's a contract in place, and it's mutually both parties agree on it. But not unforeseen, but conditions change slightly. Is a normal practice that then things still get negotiated, even though there's a contract, based on what is apparent, or should a person try and stick to that contract, even though it makes things actually more difficult? Both parties.
So the question is that let's say we have an open-ended contract. So you get different types of contracts. You speak about luzum. Speak about luzum. What is luzum? Luzum refers to the binding status of a contract. So is a contract binding or is it not binding? Is it binding from both ends or is it binding from one end? For example, a simple example is that of a gift. A gift is binding when it's taken by the person to whom it's given. So if I say, by way of example, that I give you this book, that is not binding, right? If I say that I give you the book, then it's not binding. Meaning what? That I can revoke it. But the moment you take physical possession of it, becomes binding, right? So there are certain contracts which they remain open-ended, right? And other contracts, like for example, you have the opportunity to annul them at any given time. Those are going to be your longer contracts. For example, the likes of something like qirab, where you have an investor and you have. So there you're going to, during the terms of the contract, you're going to have like the opportunity to renegotiate. But in a simple sale, the simple sale is going to be binding. There are, for example, you get something called khiyar, options, and that options will either be in relation to the contractual setting or it will be in relation to another like external stipulation. So over there, it's going to be strictly binding, but there are certain contractual relationships that are more open-ended, normally along the lines of like investments and things like that. So it will be open for renegotiation. And Allah knows best. I think we'll take the last question or last two.
It's not his to sell, but other person doesn't know it's not the owner. It means you don't even make the items actually.
It's a good question. The question is that what if a sale is invalid at one point, right? Then are we required to follow the invalidity of that sale to retrieve the item? No, you are right. So in general, they will say that consideration is given to the reality. But in the case where you can't, so in contracts, it's generally like that. The contract, in other chapters of fiqh, they will say consideration is given to what is in the mind of the duty-bound person. In that if a person thinks, like for example, if I think that I made 3 rak'ats, and then I will be considered to make 3 rak'ats. right? But if I thought that something was not mine and it actually was mine, it's still mine. So in the matters of ownership, consideration is given to reality. But the scholars did discuss this matter in that when 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 a person cannot ascertain down the line whose wealth it is, then we're not required to go back and annul the contracts backwards. You understand that? So if it's maybe between 2 or 3 parties over there, we're going to say, look, have the re-exchange of wealth, right? But generally, if it's down the line, is the Sharia going to ask you to say, is the Sharia going to ask you to ask the person, right, where did you buy this from? Where's the slip? No, the Sharia doesn't require that from you. The Sharia doesn't require that from you, and Allah knows best.
Just on that selling to minors. So does that mean that typically like all tuck shops and schools and things like that are actually invalid transactions?
According to the Shafi'i school, yes. But like we said, if you go outside of the Shafi'i school, it's going to be valid. It's going to be valid. Yes. That's how you see my students when they come to market days. I always tell them, guys, is this valid what you guys are doing here? And then they start to worry. Then I tell them, don't worry, today, halal Hanafiya. They follow the Hanafi school. Right? We follow the Hanafi school. No. طيب. I think we suffice for that for today. صلى الله على سيدنا محمد وعلى آله وصحبه وسلم. الحمد لله رب العالمين. Is there one of those books?